Hi, I'm Michael Tobin. Welcome to the first edition of Tobin Talks. Today we're going to talk about the different types of joint tenancy. What we mean by joint tenants is when there's more than one person buying a property or taking title to the property. When there's more than one person, whether it's 2 or 10, we call that form of ownership joint tenancy. You hold the property or the title jointly with someone else. Now, depending on who you're buying with, your relationship with them, the type of investment you're making, the 3 different types of joint tenancy can all have very significantly different legal consequences. And therefore, it's very important that we title the property. And when I say title, I mean on the warranty deed in the proper manner. In law, words matter. And the consequences of putting jointly held property in the wrong tenancy can be severe. So, when we talk about joint tenancy, we're talking about 3 different types of joint tenancy. And again, we're talking about owning property with someone else. The first one we call is tenants by the entirety. That is only for a married couple. It can be husband and wife, husband, wife. When a husband and wife own property together, they own property as tenants by the entirety, and that is the highest level you can get for creditor protection, meaning that if someone gets a judgment against the husband and the property is owned by husband and wife, that judgment can't be executed against the property. It also means that husband and wife or same-sex married couples, when one dies, automatically by operation of law, the property, whether it's homestead or otherwise, goes to the surviving spouse without the need for probate or other court action. That's tenants by the entirety. The next one we're going to talk about is joint tenants with rights of survivorship. This one is similar to entirety's property, but it's for 2 or more people who are not married and who have decided, 2 or 3 people, that they want to either buy property together, most likely that they're going to live in as a residence, and they've decided between themselves that when one dies, regardless of the amount of the initial investment, that the survivor will also get the property by operation of law without the need for a probate process. So we call that joint tenants with rights of survivorship because the survivor of the 2 or 3 joint tenants keeps the property. Now, this is not creditor proof from a judgment against 1 or more joint tenants. It can be attached, but the benefit of this is so that when someone dies, the parties have made it clear that their intention is for the survivor to get the property 100% free and clear of any estate proceedings. The last one we're going to talk about is tenants in common. Tenants in common is probably the most common form of joint tenancy. However, it is significantly different from entirety's property or rights of survivor's property in that when one joint tenant dies, their interest in that property goes to their estate. It doesn't go to the other owner. So if a brother and sister or 2 friends buy a property together and their investment is 50-50, and they've decided that they want to keep that 50% interest in their personal estate, either to their heirs under their will or by law, when that person dies, their interest goes according to their estate and needs to be probated. So if 2 friends buy a property and the first friend passes away, friend number 2 will then own the property with the heirs or beneficiaries of friend number 1. Likewise, you can sell a half interest in a property if you're a tenant in common. And this is very common in investment situations. So I would think of tenants by the entirety and joint tenants with rights of survivorship more for residences and joint tenants in common more for co-investors. As with anything, you should consult with an attorney and make that attorney aware of the specific facts for your situation so that that attorney can properly advise you. I thank you for your time.